Hey guys, welcome to this video. This is John Watts. I appreciate you watching this, and I realize I've been very late in getting videos out and even responding to these comments. We've been buried in some court cases. Now, if you saw my last video, you'll know that at least in Alabama State Court, our trials are going to be suspended for about 30 days due to the coronavirus. So that will give us some time to sort of get some lawsuits filed and get caught up on things. But I wanted to answer these comments here, and I thought this might be the best way to do it, just go through these. So we have Captain here who says, brilliant, thank you, come across a really nice guy. Well, I appreciate that. A question, could you explain how anyone could sue the debt collector if it turns out that the debt collectors have no claim? So I'm assuming this is in the context of being sued by a debt collector. So here's what we start thinking about. First of all, does the Fair Debt Collection Practices Act apply? So we're a consumer. Is it a consumer debt? Are we dealing with the debt collector? And then the question is going to be, can we find some violations of the FDCPA? Well, if they sue me for $5,000 and turns out I owe them nothing, well then have they misrepresented that? Have they made a false claim? Well, that would be under Section E, which is a misrepresentation or deception. Well, is it unfair to sue me if I do not owe any money? Well, that would be under Section F, for unfair conduct. Now, we also look at things such as credit reporting. So did they tell the credit bureaus I owe $5,000 and it turns out I owe nothing? Well, then is that false credit reporting? Did I dispute with the credit bureaus? That might bring in the Fair Credit Reporting Act if it's been verified. We might look at malicious prosecution, which is a state law tort that says basically if you bring a lawsuit and there's absolutely no justification, no arguable reason for bringing it, well then that was just brought with malice. So it's a malicious prosecution. And so we sue for that. And so you do have to look and see exactly what happened. So if they show up at trial and they have no witness and no proof, and they just show up and go, oh wait, we were hoping you the defendant, the consumer, would not show up so we could win, we have nothing. Well, that's a different matter than if they fly in witnesses and they try every effort they have to win the case and they just happen to lose. So we have to look at various things, but we certainly have filed, I can't tell you, I think we sued Midland, I stopped counting maybe 4 years ago. I think we'd filed 50 federal court lawsuits against Midland Funding, all arising out of the lawsuits that they filed against our clients as consumers. So you definitely can do this, and we've sued a bunch of other companies. So it's definitely something to look at. So then JW, I like that name. JW says, would I have a claim under 1698 if this happened? Medical bill went to collections. I called the original creditor and paid them. They pulled it out of collections. The debt collector still reporting it on my credit report now as a zero balance, even though I paid the creditor. That would be a violation, correct? Well, so tell me exactly what you mean by 1698. So let me just talk in general terms. If you owed the medical provider, then the debt collector has the right to credit report as long as they're doing that accurately. If you then pay the medical provider, then the debt collector, really most of them will just delete the account. But if they don't delete it, then they should immediately update it to show a zero balance. Sounds like they are showing it as a zero balance. I would look at the timeline. In other words, you paid it here. The next month, did the debt collector report it as zero balance? Or did it take 2 months or 3 months or 4 months? Because that could be a claim. I'm not saying they have to update it the very next day, but certainly every month they need to update it correctly and accurately. You might also dispute it through the credit bureaus and say, look, this is a medical account. Explain what happened. Was insurance supposed to pay or whatever? I paid it. I want it deleted. A lot of times the credit bureaus will delete that. So that may solve the problem for you. But I can tell you right now, we've got some cases we're filing against debt collectors who report medical debt because they were not reporting it accurately. And so if you can find any inaccuracy in there, and I'm not talking about like it's a dollar off, but something that makes a difference, then you certainly could look at suing them. And again, look at that delay in time. So you pay it the next month. Is it reporting a balance the next month? I mean, if you go 2 months, I would definitely look at suing. Maybe even 1 month, look at suing. So I hope that helps. All right, let's see. Now we've got Avocado and Megs. I ended up settling with the debt collector that was suing me. Total amount was $585, and we settled on $468. I received a copy of paperwork today from the courts that says dismissed without prejudice. So first of all, that means that they can sue you again. Just like putting everything else aside, a lawsuit that's dismissed without prejudice means they have the ability to sue again as long as it's within statute of limitations and as long as you still owe the debt. Can I do anything to get it changed with prejudice? Maybe. You have to look at what was your agreement with the debt collector that you settled with. Normally it should be with prejudice, but it may not matter here because I think I know where we're going. So let's see. I also noticed that they reported to credit report I paid down $468 off, but the balance isn't zero. So what are they doing exactly? Okay, I call the attorney's debt collection agency, and they're saying my account is closed with them now that's dismissed. We've settled the account. Are they trying to pull something on me? This is aggravating. Want it out of my life. Absolutely understand it. Be terribly aggravating. So here's what I would say to you. So they say that you owed, we'll just call it $600, and you paid about $500. And it sounds like they're reporting that, $100 balance or whatever the actual numbers are here. To me, that is false credit reporting. Absolutely false credit reporting. If you have a settlement and they say you owe us, $600, but pay us $500 and we're even, well, then it should be a zero balance if it's going to be on your credit report at all. Now, I would look and see, is it the original creditor that is showing that balance, or is it the debt collector showing the balance? If it's a debt collector, then, and if they've updated the balance, and sounds like they did, so they recorded your $468 payment. So they've updated the credit report, but with a false balance, and I would look at suing, and that would be under Section E8 of the Fair Debt Collection Practices Act, the FDCPA. So, was it 1692 E8? That's what I would look at there. And so definitely I think that that's something that you could do. And I would look at other provisions of the FDCPA as well because, the question is, when they settled, did they lie to you about settling? Well, if they're keeping a balance, it looks like it. But even if they didn't lie, they're still reporting false information on your credit report. So I would definitely take some action on that. You may want to dispute it through the credit bureaus. I'll tell you this, we had a similar situation. So a client was sued, and we'll just, say $5,000, they paid $3,000, credit bureau, and the debt collector updated it to show they owed $2,000. We could have sued right then, okay? Absolutely could have sued. And that would have, $5,000, $7,500, $10,000 value. But we had the client do a dispute through the credit bureaus and say, hey, look, this debt collector knows I owe nothing. They know that. Don't let them report that I owe $2,000 if they won't show it as a zero balance. Delete the whole thing. Well, it comes back verified. The debt collector said, no, you do owe $2,000. So we sued, and I think I mentioned this in another video. I mean, those cases when you dispute, at least the way I look at them and the way that I resolve these cases, I say that has probably at least 5 times the value as if you just sued without disputing through the credit bureau. So you still have the FDCPA, but you also have the FCRA, Fair Credit Reporting Act, and you've also given that debt collector a chance. So if you dispute it with, let's say, the 3 major credit bureaus, Equifax, Experian, TransUnion, each of those guys will send the debt collector a notice of dispute saying, hey, this person disputes owing you any balance. And so it means not only did they put false information as soon as they updated your report, but then they told Equifax false information when they investigated it. Experian false, and TransUnion. So now you got them doing false information at least 4 times. So it just makes it harder for them to say, oh, we made a mistake, we're so sorry. Now, they'll still argue that, they'll say, oh, we hit F5 instead of F7 or whatever. They'll still argue that it's a mistake, but it's kind of hard to keep making the same mistake over and over and over. So I would definitely look at that. And if you're in Alabama, feel free to give us a call or get in touch with us. And if you're in another state, then get with the consumer lawyer in your state. I definitely think that's worth looking at. So Keith Fisher says, great content. I've been a credit information junkie for years. I believe it's a need for helping people find answers to impossible credit challenges. Can we talk? Thanks, Keith. Yeah, Keith, just shoot me an email, john@wattsherring, WATTSHERRING.com, or just fill out our contact form on our website, alabamaconsumer.com. Be happy to chat with you. And then let's see, CNDVD says, the court and law firm suing me, they've been intentionally causing delays, rescheduling, not showing up, which is already 2 years and no judgment, just intentionally wasting my time coming into court, which I know is a violation of the FDCPA. This law firm filed the case just within statute of limitations, set to run out by 2 months, trying to get the case dismissed by statute of limitation, even though the law firm filed the case in time because there's 2 months and it would have expired. Since it's about time, and law firm and court keep wasting my time. Judge recently did not know about the FDCPA laws. Case already 2 years in, about 8 court appearances. I believe I could prove to a jury that wasting my time. Statute of limitations should expire. Okay, so totally understand your frustration. You're dealing with something where it just keeps dragging on and on. And look, I'll just answer this based on Alabama law. So they filed the lawsuit here. Here's when the statute of limitation would expire. As long as they file it before, then you can't win on statute of limitation. It doesn't matter if that case goes on for 20 more years. And look, it's very unusual. But occasionally cases might go for 5 years or 10 years. Statute of limitation, we just look at when was suit filed and when did statute of limitation. Was it filed before the statute or was it filed after the statute? If it's after statute, great defense. Before statute, even 1 day, 1 minute before, then there's no defense. Now, maybe it's different in another state. I don't think it will be, though. So I definitely understand the frustration. If you have a lawyer, definitely get with your lawyer. If you're doing this on your own, you may want to file something with the court and ask for a status conference or file what's called a motion to set it for a jury trial, or for, if it's a non-jury, set it for a non-jury trial. In other words, something to kind of prompt that judge and, hey, let's get this thing moving. And most judges, I find, are very receptive to that. So sorry I don't have a better answer for you. I wish I could say because they're dragging their feet, they're delaying it, you can get the whole case thrown out. That's not true in Alabama. I mean, they'd have to violate a bunch of court orders, and then the judge may throw the case out, but that's pretty unusual for that to happen. All right, thanks. You're great. Hey, I appreciate it. Let's see, what amazing video. Thank you so much. I'm in New York. Use your techniques. Keep you posted. Well, I appreciate it. As I always tell people, if you're not in Alabama, you definitely want to check out your own courts. I would suggest get with a lawyer in your state and just see how much do these things parallel. Sometimes they're very similar. Sometimes they're very different. So ultimately, you need to know what's happening in New York. And like the video I put up earlier today, your courts may be shut down, so you definitely want to check on that. Thank you. Well, you're very welcome. Let's see. Okay, this is CNDVD again. Once a lawsuit is filed, statute of limitations freeze. Can any acts by the plaintiff or law firm representing them allow the statute to run out? Not really. Now, a case can be dismissed for what's called lack of prosecution. In other words, the lawsuit was filed and then nothing happens. And eventually the judge may get frustrated and say, look, I'm not going to just let this sit and do nothing. I'm going to dismiss the case for not moving the case, not pushing it forward. It says they've been taking me to court for 2 years. Nothing happens. They don't show up. Court gives them another date. Well, that is very frustrating. If they don't show up, you may ask the court to dismiss the case. At least in Alabama, we'll see judges do that. So, like they're breaking the Fair Collection rules, wonder if I can get the judge to dismiss the case since they're doing illegal acts using courts to delay. You certainly could ask for that and make sure you're clean. In other words, make sure you showed up every time. They're not showing up. And I would point out to the judge, I mean, you don't want to exaggerate anything, but be just completely truthful. Have I had to take time off from work? Am I a caregiver for an aging parent? I've had to hire sitters to come in while I show up at court. Do I provide, care for my children? Had to get a babysitter. I mean, just explain to the court why this is really a big inconvenience. I've showed up this time, and the other side hasn't shown up. That's why I'm asking that you dismiss the case. So you certainly could look at doing that. Law firm is buddy-buddy with the courts. They do so many cases. I'll say this, because I deal with courts all over the state of Alabama. And, people will bring us in for where we're suing somebody, a debt collector, a credit bureau in other states. So deal with judges a lot of times, a lot of different places. But you may have a judge that sees a lawyer a bunch, and there's a certain familiarity there. But usually what I've noticed, at least in Alabama, is the judges, they're friendly with the collection lawyer that may file a bunch of cases, but they're not going to let them just drag what's called the docket or just drag cases out. So I would not hesitate to do it in a very respectful, professional, no exaggeration or anything like that, but just point out to the court, here's why this is bothering me. Could you please either get them to move forward with the case or throw the case out? And I think the judge may be receptive to that. Let's see. Then we have Mark Davis, not showing up court's number one thing gets people in debt collection lawsuit. Yeah, that's absolutely right. I mean, you're sued and you just don't show up. That could mean not filing an answer, so you get a default judgment. Or you file an answer, that's great. You get a trial date. You don't show up at trial date, you lose. Now, as we were just talking about with this previous comment, sometimes it seems a little unfair. Maybe the collection lawyer does not show up and the judge says, oh, no problem. But I promise you, if you don't show up, it is almost guaranteed that there will be a default judgment against you, at least in the state of Alabama. So just you got to show up. So appreciate that, Mark. Let's see. Monk says, I'm being sued for $2,500. Isn't it going to cost debt collectors more if we go to trial? Seems so. Plus, the lawyer they hired lives an hour away. I think my chances are pretty good. So here's something to think about, Monk. We can't always use common sense, okay? So I now see routinely cases filed in Alabama where we might have $100, $150 filing fee, and the lawsuit will be for $500. And the lawyer is filing that maybe 4 or 5 hours away. That's where their office is compared to court. You say, how could that be profitable? Well, for one, it may not be profitable, but the lawyer may say to a company like Midland Funding, LVMV Funding, yeah, I'll take your $500 lawsuits because I want your $5,000 lawsuits also. And the debt buyer may say, you only get the bigger cases. And look, we just had a case recently that was a 6-figure collection case, okay, where our client was being sued for 6 figures. So they may say, if you want those big cases, you got to take these little cases. And so it's kind of a loss leader, if you will. Just like a grocery store may sell milk for real cheap just to get you in so you buy the other stuff. The other thing is, being 1 hour away, I mean, I see collection lawyers that will drive 5 hours because when they get there, it's probably not just your one case. They may have a dozen cases, 24 cases. The other thing is if they can't physically be there, they'll get what's called an appearance counsel to show up for them. And again, that lawyer may come in there and she may have a dozen cases. And so even though they're really small, they make a couple $100 on each case, then it can still be profitable. So, and I don't think you were saying this, Monk, but, don't say, well, it's not going to be worth their time, so they won't put any effort into it. No, they'll show up, at least in Alabama, the lawyer will show up. So you definitely show up, make sure you're prepared, you're ready, and take it seriously, which I'm sure that you are. And good luck with that. Let us know what happens with it. And let's see, then Mark Davis, sit through these trials from time to time. Few that go to trial, pro se defendants often make the debt collector's case for the most or default judgments. And Mark is in Texas. So yeah, absolutely, Mark. I mean, people don't show up. and file an answer, so they lose. And then when they have their trial, a lot of people don't show up. The ones that do show up will just, agree to a judgment against themselves. And even the ones that try the case, a lot of times, you're right, the pro se defendants make the debt collector's case for them. And I saw one where they were asked, "What are we doing here today?" And the consumer said, "Well, I defaulted on this debt, and your client, whoever it was, bought the debt, and you're now suing me." Well, you just made the debt collector's case. So hopefully this video, the 7 mistakes when testifying, will help a little bit with that. So thank you for that comment, Mark. And we'll end it here with Jason. Thank you so much for posting videos. Truly make a difference. You helped me win my case. Thank you. So, well, you're very welcome, Jason. I'm glad you won your case. Definitely check your credit reports and get with the lawyer in your state to see if, by fact of winning your case, does that allow you to dispute it with the credit bureaus to say, get this off of my report? Okay, that's at least true in Alabama. And sometimes you don't even have to dispute it. If they, for example, update it after you win your case, you may just sue them directly. I like to dispute it because, frankly, it makes the case a lot more valuable. And so anyway, guys, thanks for the comments. I apologize for being out of touch here, but we'll try to make the videos more regular and keep the comments coming. And thank you so much. You guys have a great one. Bye-bye.